The Peace Officers Discipline Procedures Act, otherwise known as POTA, requires agencies to follow certain procedures when, during the course of investigating allegations against a licensed peace officer, it is necessary to take a formal statement from the officer. Licensed peace officers and part-time peace officers employed by an agency have special statutory rights. The Peace Officers Discipline Procedures Act, or commonly known as the Peace Officers Bill of Rights, is a statute that provides special rights related to obtaining a formal statement from an officer for access to information that will be used in a later administrative proceeding, as well as requiring an agency to provide a copy of discipline letter to the officer. A formal statement of an officer may not be taken unless a written complaint signed by the complainant stating the complainant's knowledge is filed with the investigating agency, and the officer has been given a summary of the allegations. The formal statement must be taken at a facility of the employing or investigating agency or at a place agreed to by the investigating individual and officer. Sessions at which a formal statement is taken must be of a reasonable duration and must give the officer reasonable periods of rest for personal necessities. When practical, sessions must be held during the officer's regularly scheduled work shift. If the session is not held during the regularly scheduled work shift, the officer must be paid by the employing agency at the officer's current compensation rate for time spent attending the session. The officer whose formal statement is taken has the right to have a union representative or attorney retained by the officer or both present during the session. The officer may request the presence of the attorney or union representative or both at any time before or during the session. When a request under the subdivision is made, no formal statement may be taken until the reasonable opportunity is provided for the officer to obtain the presence of the attorney or representative. Before an officer's formal statement is taken, the officer should be advised in writing or on the record that admissions made in the course of the formal statement may be used as evidence of misconduct or as the basis for discipline. A complete record of the sessions at which a formal statement is taken must be made by electronic recording or otherwise. Upon written request of the officer whose statement is taken, a complete copy or transcript must be made available to the officer without charge or undue delay. The session may be tape recorded by the investigating officer and by the officer under investigation. Upon request, the investigating agency or officer shall provide the other party with a list of witnesses the agency or officer expects to testify at the administrative hearing, including arbitration, and the substance of the testimony. A party is entitled to copies of any witness statements in the possession of the other party, and an officer is entitled to a copy of the investigating agency's investigative report. No disciplinary letter or reprimand may be included in an officer's personnel record unless the officer has been given a copy of the letter or reprimand. In addition to following the steps of the Peace Officer Bill of Rights, when disciplining or discharging a police officer, the employer should be careful to follow special internal policies developed to address misconduct complaints against police officers. In Minnesota, these internal policies are required by the state licensing board known as the Peace Officers Standard and Training Post Board. The Post Board requires every chief law enforcement officer to establish written procedures for the investigation and resolution of allegations of misconduct against licensed police officers employed by their agency.